Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello, and welcome to Our Curious Amalgam, the podcast from the Antitrust Law section of the American Bar Association. I'm Matthew Hall. Today's episode is A Power Grab Too Far, Part 2, the European Commission investigation in Illumina Grail. This is a follow-on episode to our episode number 141, released on 15 November 2021, which was called A Power Grab Too Far, the European Commission extends its merger control reach. We will be discussing today the further issues raised by the saga of the European Commission's merger control investigation into Illumina's reacquisition of its former subsidiary Grail. Despite Grail having no turnover in the EU, the European Commission controversially claimed jurisdiction over the acquisition using Article 22 of the EU merger regulation and, following a detailed investigation, blocked it on 6 September 2022, rejecting Illumina's offer of remedies to fix the problems found by the Commission. Meanwhile, Illumina appealed the Commission's assertion of jurisdiction and lost that appeal at the EU General Court. That loss has now been appealed against the General Court judgment, and the company has also said that it will appeal against the prohibition decision and any order by the Commission to divest Grail. Today we will focus on the substantive issues raised by the case, which is, after all, the driver for the Commission's jurisdictional claim, some practical lessons arising from the procedural fight, and also a comparison with the US position. My co-host today is Jeny Maier. Hello, Jeny.
Hi, Matthew. Glad to be here.
Well, thank you very much for co-hosting today. Who is our guest?
We have a distinguished guest today. Our guest today is Philippe Chappatte. Philippe is a partner at Slaughter & May. He's resident in the firm's London office, but also is established in Brussels, where he spends a proportion of his time. He's a member of the Brussels Bar, as well as a qualified solicitor in England and Wales. Philippe has been recognized for his legal skill and his thought leadership by Chambers, the Legal 500, and Who's Who Legal. Philippe has extensive experience on both EU and UK competition law, with expertise in merger, cartel, behavioral, and competition litigation cases in both jurisdictions. He is the president of the European Competition Lawyers Forum, which is used as a sounding board on policy and practice-related issues by the European Commission's Competition Directorate General. Philippe has acted on behalf of many global companies in high-profile matters, including for Booking Holdings, Allergan, the Stars Group, Calder, Ineos, Bertelsmann, and many others. But most notably for today's purposes, though, Philippe has advised Illumina on its acquisition of Grail. We're very grateful to have Philippe's expertise and his insights for this episode of the podcast. Welcome, Philippe. And so, as a refresher for those listeners here who are not familiar with the particulars of the Illumina Grail transaction, Illumina is a leading global provider of DNA sequencing technologies to support advancements in oncology, genetic disease, microbiology, and other emerging life sciences segments. Illumina formed Grail in 2015 with the goal of developing a test that's enabled by Illumina's sequencing technology to detect multiple types of cancer through a blood draw. In 2017, Illumina spun off Grail while retaining an ownership interest in the company of less than 20%. After the spin-off, Grail raised additional capital and continued to develop its multi-cancer early detection test called Galleri. In September 2020, Illumina entered into a merger agreement to acquire the shares of Grail that it didn't already own for a total consideration of about $8 billion. And so that's the transaction that has caused all of the events that we're going to discuss today. So Philippe, perhaps just to set the stage, as Matthew said at the outset, the European Commission prohibited the transaction after engaging in a full phase 2 review on the basis of vertical foreclosure concerns. Can you give us a summary of how the Commission assessed the foreclosure issues in its decision?
Well, first, thank you very much for inviting me to join your ABA series of podcasts. It's a great privilege to be talking to you all. So the first point is that this is not a merger of competitors. It's not a horizontal merger. So we're into the less well-known, less thought-through theories of harm known as vertical foreclosure. And according to well-established principles, to establish a vertical foreclosure case, the authority has to do two things. It has to prove that the company that is supplying the input, in this case Illumina, that supplies DNA sequencing equipment, has the ability to foreclose. That's the first step. And secondly, that it has the incentive to foreclose Grail's competitors. So upstream, you have Illumina producing DNA sequencing equipment, and downstream, you have Grail that runs basically cancer tests using DNA sequencing equipment. And the vertical foreclosure theory of harm was about whether Grail's so-called competitors, who are also largely reliant on Illumina sequencing equipment, will be foreclosed. So turning to the issue, does Illumina has ability to foreclose? So Illumina is, as Jeny has pointed out, the leading global supplier of DNA sequencing equipment. Whether Illumina has the ability to foreclose depends if there's any other company that is a credible alternative supplier of DNA sequencing equipment to Grail's competitors. If there are any credible alternative suppliers to Illumina, then Illumina would not have the ability to foreclose any downstream competitor, because any downstream competitor of Grail could then switch to the alternative upstream supplier. Turning to the second point, does Illumina have the incentive to foreclose? So you have ability and incentive. This turns on whether Illumina is likely to make more money by selling more Grail tests than it loses by not supplying Grail's competitors. This is what we call vertical arithmetic. So in a vertical foreclosure case, Illumina is bound to lose income by not supplying Grail's competitors with DNA sequencing equipment. And that only makes sense if they're going to make more money downstream by Grail post-merger selling more tests. So that depends on whether Grail has any close competitors. If Grail doesn't have any competitors, then foreclosing Grail's competitors makes absolutely no sense, because that foreclosure will merely cause upstream harm in terms of lost revenue without any downstream gain, because foreclosing A and B, who are not competitors to Grail, won't generate more sales by Grail. So that's the theory of harm.
And so in the decision itself from the Commission, what facts did they rely on to come to their conclusion that there was foreclosure in this case?
So there are two critical issues of fact. So to make its theory of harm stick, the Commission has to establish that Illumina has no credible upstream competitor. So in this market, Illumina has a very strong position, particularly in the United States, in the upstream market, because it had blocking patents, which were just about to expire. So the issue was on the expiry of those patents, would there be credible alternative competitors? And Illumina argued that companies like BGI, which is a Chinese company, and other new entrants would enter the US market and globally once these patents expired very shortly. So Illumina had a great witness called Dr. Cote, who was not only a professor of medicine in a leading university in the United States, but he knew and very experienced in cancer screen testing. But he also knew a lot about BGI. He'd gone to China to look at BGI's equipment and see whether it was a credible alternative to Illumina. And he concluded that, well, he in fact put an order in for his research institute because he wanted to use BGI equipment for the same applications as Illumina. But the commission rejected his evidence and preferred the evidence of Grail's competitors who were trying to prevent this deal from going ahead on the basis that Dr. Cote was a paid witness. You will find that surprising as US lawyers, that a credible witness is not regarded as having plausible or convincing evidence merely because he is paid. So the commission put much more weight on the evidence provided by Grail's competitors. So that was the first issue of fact. And the second issue of fact related to whether Illumina had incentives to compete, and that goes to the issue as to whether Grail had any credible competitors. And Grail's test was a revolutionary breakthrough cancer screening test, which could test for 50 cancers in a single blood draw and tell you which cancer you had. And it's a breakthrough test with hopefully will have fantastic results and save many lives. None of the alternative test companies, the so-called competitors who said that they were going to be foreclosed, had anything more than a single cancer test, and had not conducted trials or started trials on multiple cancer tests. So Dr. Cote gave evidence and said and provided very clear evidence that, having analysed each of the alternative suppliers, that none of Grail's so-called competitors had a credible alternative test that was likely to enter the market anytime soon. And if they did, those tests would be complements rather than directly competitive with Grail's test. So again, the commission disregarded Dr. Cote's evidence, even though it was by a leading scientist, and gave weight to Grail's competitors in concluding that Illumina did indeed have incentives to foreclose Grail's competitors.
But Philippe, there seem to be two particular issues which, at least judging from the public material, distinguish this case from a normal vertical foreclosure case, which you've been describing to us. The commission refers to it as harming innovation competition, and also, at least when looking at incentives to foreclose, it seems to look at an extremely long period, looking out to 2035, which is, by any measure, a long way away. Who knows what would happen in that period? Can you comment on those two particular points and how they played into this?
Yes. So this is really a case involving the extension of the Commission's approach to potential competition. So in a classical pharmaceutical case, the Commission and indeed the agencies in the US take into account when assessing potential competition in pharma, products that have reached phase 2 or phase 3 of their development. And phase 2 and phase 3 products are subject to trials. And at that stage, you can identify that there is a test and what that test is seeking, or that drug is seeking to do. And therefore, you can assess the potential, the impact of that drug on the market if it is successful. So the Commission in this case took the competitive assessment much further and basically concluded that it was enough to be in the competitive race. They regarded the Grail's competitors as being competitors in a race for innovation, and these competitors had not got to the stage of developing a multiple cancer test that was subject to trials, and that's very clear from the FTC's findings that we can come back to perhaps at the end. But it was very clear that the only tests that had reached the stage of trials that had been developed by so-called competitors were single cancer tests that are used for completely different applications than a 50 cancer early screening test, and therefore not likely to take sales away from Grail. So I think that's the significance, is that the Commission has extended the concept of potential competition much further back in the R&D chain, and takes into account now and seeks to protect competition at a very early, very speculative stage, where it seems to be sufficient for companies to say, I have the ambition to compete, and I'm investing in similar sorts of products, and that's enough to trigger the incentive to foreclose. So the American judge threw that out and said there was no evidence to suggest there was the incentive to foreclose. He cited the Arch Cole case and said antitrust theory and speculation cannot trump facts. So facts are important, and I think we would say on the Illumina side that the Commission's theory of harm was highly speculative.
Do you think that that would extend beyond the pharma area? Maybe it's easier to measure this type of thing in the pharma area than it is in other industries, given you have stages, as you were discussing. Does it go beyond this area into other industries?
Yes, I mean, I think it does. It does extend to other industries where there's a potential for competition. There is the Paroxene case, which establishes, which is a leading case on potential competition in the Article 101 field, which establishes that you've got to have taken clear steps to enter a market and be likely to do so in the foreseeable future before you're accepted as a potential competitor. This case is clearly trying to move the dial relative to the Paroxene case.
Okay, so it's something we should watch out for more generally. Moving on to another area, Philippe, the Commission's press releases at least don't refer to the issue of efficiencies, but if you look at public statements made by the company, it seems to make quite a lot of play of this area, even referring to the EU's kind of general policy goals to protect the population's health generally, essentially. Did you, or were efficiency arguments raised throughout the process before the Commission? And can you take us through what those were?
Yes, and Illumina published a paper prior to the statement of objections being issued that set out its case on efficiencies. I mean, this is a case, probably the strongest case on efficiencies that I have come across, because there was robust evidence from the internal documents of both companies that substantiated those efficiencies. And those efficiencies were effectively that Illumina had a clear plan in its transaction business model to enter the European market in the near term, by 2025, 2026. And having done so, and that they would enter the market at scale. So there was clear evidence based on business plans which went out to 2030 that Illumina was expecting very substantial sales of this Grail test throughout the EA by 2030. And in contrast, Grail was about to launch an IPO, and it had a plan, as always for IPOs, rather aggressive plan, which suggested very substantial revenues at a time when the company had zero revenues. But they put out a forecast to 2030, which they were preparing for the IPO, which envisaged zero sales in the EA by 2030. So based on contrasting those two plans, the companies put together estimates of how many lives would be saved in Europe if the Illumina plan went through. And unfortunately, the Commission rejected the evidence on the basis that they thought the Commission would, that Grail, as an independent company, would enter the EA market in any event, despite the evidence put forward by the parties.
So it's interesting that you had these pre-existing plans, which is obviously usually extremely helpful, but despite that, the Commission couldn't take that on board. Looking at that experience, I mean, you, as a very experienced practitioner, refer to it as the strongest case on efficiencies you've ever seen. It is notoriously difficult to win a case on efficiencies, certainly in the merger control area. Do you think that this lesson or this story is useful for other cases, telling you that really efficiencies is just more or less impossible, or do you think there is still ever an opening here?
Well, I tend to always argue for efficiencies in cases because it tends to colour competition authorities' views about mergers. Is this intuitively an anti-competitive merger, or is this intuitively a merger that is good for consumers? So I think I always argue them. I've yet to win a single case based on efficiencies. I've yet to have a case either in the UK or in the EU or any other jurisdiction where efficiencies have trumped substantial anti-competitive effects. I mean, if you listen to what the chief economist says, he says efficiencies are very important. So, and they're very important, he would say, certainly at the margin. So when you're talking about remedies and you're trying to argue that certain remedies are sufficient, in crafting those remedies, it's sometimes possible to say, we want to go so far but not further because that would undermine the efficiencies. And in that context, at the margin, you can see efficiencies playing a role in actual cases. But I think I'm hoping that in this case, the efficiencies arguments get tested at the level of General Court and potentially up at the European Court of Justice, because this is a case where efficiencies should have played a role, in particular taking into account the guidelines, the EU Commission guidelines, which I think the court will give weight to, which say when you're seeking to prove efficiencies, you should be proving them based on internal and company documents. And in this case, it's exactly what we did, right? We contrasted two business models and said, Bob's your uncle, here's substantial efficiencies. And the Commission said, no, we will ignore those business models and we'll look at other facts that suggest that there might be imports or there might be sales of Grail tests before 2030, even though not a single dollar was included in the IPO business model prior to 2030.
Well, they kind of contrast, as you say, between what the ordinary course of business documents showed versus what the Commission ultimately concluded is an interesting phenomenon. Are there any other sort of takeaways from the Commission's analysis that we could at least, take away and think about other potential transactions, especially vertical transactions for the future at the EC?
Yeah, I mean, I think that there's sort of three takeaways. I mean, the first is that, as we all know, this is a really tough environment to get any mergers through when you're dealing with companies who have very strong market positions upstream, so certainly in vertical cases. This deal would not have been investigated at all 5 to 10 years ago. A deal involving acquisition by an American company of a company that had zero turnover anywhere in the world would, I don't think, have been investigated anywhere in Europe. So we're living in a very different climate today. Secondly, as you say, vertical cases. I've been doing merger review cases for over 40 years. Vertical cases usually used to pass through relatively easily because they were presumptively pro-competitive, because economists have argued for many years, based on extensive studies, that vertical mergers give rise to efficiencies which normally translate into consumer welfare benefits. But we've now come full circle, where vertical cases are more difficult to get through than horizontal cases, because if there is a vertical foreclosure case that sticks, you can't use behavioral remedies anymore. So they ultimately end up being prohibited, whereas historically, either they weren't investigated at all, or they were cleared, or in the worst case, you get through on behavioral remedies. So we're now in this very odd situation where, according to standard economics, there is not a lot of substantive economic studies which establish that vertical mergers are anti-competitive or undermine consumer welfare. And yet they're now more difficult to get through, both in the US and in Europe, than they were historically. My American friends tell me that the US authorities haven't won a vertical foreclosure case in the courts in the last 40 years. So it'll be interesting to see whether the authorities manage to get a federal judge to injunct a vertical foreclosure case. But certainly in terms of approach and rhetoric at the level of the competition authorities on both sides of the Atlantic, this is a really tough time to get vertical mergers through. So that's point 2. And I think the third point is that it is very difficult to get mergers through when you have a number of very vociferous complainants. I think the competition authorities, and I have some sympathy for them, find themselves in a very difficult position where they have to look at two worlds, the world according to the complainants and the world according to what the companies are going to say. And I think there's going to be a tendency for the authorities to side on behalf of the complainants in a world which is much less friendly to mergers than it was historically. So those are my 3 takeaways.
That's great. And kind of that's the substantive side. And maybe we'll flip back for a moment and talk about the procedural side, because that's equally interesting from my point of view. As we discussed at the outset, the General Court had turned down Illumina's appeal against the Commission's Article 22 jurisdictional claim back in July. And I understand that Illumina has appealed, but we'll stay away from the specifics of the appeal for now, since that is pending. But are there sort of general points of application from the General Court's judgment that we as practitioners should be aware of? Any particular risk factors or practice pointers that deal makers should keep in mind if they are facing similar circumstances in Europe with no revenues?
Yeah, I think the surprising conclusion that the General Court reached, I think it's lawyers recognize that the language of the merger regulation is not clear. So it's ultimately a question of what is the purpose and what is the context of the relevant legislation, and the General Court came out the way that it did. But in the court's reasoning, when it addressed the issue of legal certainties, because I think the big argument is that the new Article 22 policy introduced a lot of legal uncertainty, and that was argued in front of the court. The whole basis of the European merger regulation is a one-stop shop, the famous one-stop shop. You could go to Brussels and you can get a single clearance, and you can get clearance for the whole of the EU, and business and member states gave the Commission that power to regulate mergers on the basis that there would be the benefit for business of the one-stop shop. And the one-stop shop based on very clear turnover-based thresholds. So the court says, no, that's not the purpose of the merger regulation. The purpose of the merger regulation is to enable the Commission to intervene whenever there's a risk to competition. That's a very, very different approach. And they address the issue of legal certainty by saying, it's okay, companies can make 27 notifications in 27 member states and get clarity. Well, that's not, we would say, an answer to concerns about legal certainty, because the burden on companies and the uncertainty creates with potentially different results in different jurisdictions. That is not the deal that European business and the member states in 1989 when they were discussing this. And I remember I was there. I remember, the discussions that Leon Britton presented to convince member states and the European Parliament to give the Commission this power, which was a revolutionary power. Nobody would thought the Commission would never be efficient enough to be able to process cases in 1 month. It was unheard of for the Commission to take decisions in 1 month. But anyway, the Commission was granted that power based on clear principles, which I think have been seriously shaken by this General Court judgment. So we'll have to see what the top court decides. Hopefully there'll be wiser men and women.
Yes, well, I know that a lot of merger practitioners are eagerly following the developments here in order to, better advocate and counsel our clients in transactions to be able to, allocate the risks and the filing obligations. Because right now it's quite a challenge given where the law is at in Europe. So we will certainly stay tuned. So flipping now to the other side of the Atlantic in the United States, as you referred earlier, the FTC sued to block the transaction at the end of March of 2021, filing both a motion for a preliminary injunction in federal court, as well as a complaint in the FTC's internal administrative court. And in May of 2021, the FTC dismissed its federal court action because of the pending review by the European Commission, which had taken jurisdiction under Article 22 to review the transaction in April of 2021. So the case proceeded in the FTC's administrative court, and the FTC's administrative law judge ruled in Illumina's favor in September of 2022, finding that the FTC had failed to prove its case that Illumina would have the ability and the incentive to advantage Grail and to the disadvantage of Grail's rivals. So the ALJ's decision has been appealed by the FTC, and so it will now be decided upon by the full Federal Trade Commission. From your perspective, why do you see the difference in outcome here before the ALJ in the United States? Aren't these really, worldwide markets with the same facts?
Yeah, you're right. The FTC and the European Commission were applying exactly the same framework. You have vertical foreclosure, you need to establish ability to foreclose and incentive to foreclose. So the economic theories and the concepts were exactly the same. And as you know, it's very rare for an FTC administrative judge to reject the arguments of the FTC. My American friends say that happens in less than 90% of cases. So the judge came to a different conclusion, essentially on the basis that he gave weight to Illumina's expert evidence rather than statements of complainants. And that goes to the point I was mentioning before, that Dr. Coty, he found that he was cross-examined at length. He found him to be a very credible witness, and I spent a lot of time with Dr. Coty. He's a very credible person who's extremely knowledgeable about these tests. He's set up companies to develop cancer screening tests. He knows all about cancer screening tests, and he knows all about this whole field. And the judge basically said he's credible, and the complainants did not produce evidence that their tests would be able to do the same sorts of things that the Grail test. And you remember the Grail test is a 50 cancer test with the ability to tell you which cancer you've got. And that's critical for a cancer screening test, which is used in the general population. So the idea of the Grail test is those of us who are over 50 will every year go to our general practitioner and get this test, and he will tell us with a high degree of accuracy, 0.5% false positive. So extraordinary levels of accuracy. If the test says you've got cancer, it will give you those sorts of results and cover 50 cancers. And none of the other tests that were so-called competitive were subject to trials for more than a single cancer. And the gulf between a single cancer test and a 50 cancer test is enormous, because each time you add a cancer to a test, you increase the false positive rates. Anyway, it's getting probably a little technical, but there was no evidence that we found on the Commission's file that contradicted Dr. Coady's conclusions. What the Commission relied on were basically interviews with complainants and no underlying documents. And if you compare that process of evidence collection with cross-examination before a judge in the United States, it's a very difficult process. And the statements made by the so-called competitor Grail were subject to a level of scrutiny in the US that they were not subject in the European system. And I'm hoping that will also come out when the General Court looks at it. I think it's going to be difficult. It can be a difficult case on the substance, because the Commission took their decision before the FTC judge. A matter of what the internal decision was taken a couple of weeks before the FTC judge came out with his judgment. If the judge had come out with his judgment maybe a month before, maybe the outcome in Europe would have been very different. But now the Commission's got to go and defend its case in the General Court with these very different conclusions in the US, precisely on the points that we've argued. So I think that's the key difference. In the US, you've got proper cross-examination, and in Europe, you have a different system which doesn't subject third-party comments to the same level of scrutiny.
Interesting observation. And perhaps if we want to zoom out a little bit, this case, I think, has presented effectively a perfect storm of difficult substantive analysis, some challenging facts, as well as a layer of procedural uncertainty. What, at a high level, would you say are some practical lessons or advice for parties to global deals from this experience?
I think one really important aspect of this case, which and it's not unique to this case, is that the case was going to a federal trial, not to an FTC administrative procedure, but to a federal trial in the United States to block the transaction. And shortly before the cross-examination in the US was going to take place, the FTC withdrew its application for injunction. And it was able to do that because the parties were not allowed under the EU rules to complete their transaction. And so if you've got a situation where there are parallel investigations in the US, there's a court procedure, injunction procedure in the US, and at the same time you've got second phase inquiry in the UK or an EU filing, then the FTC is not the FTC and DOJ can avoid the challenges of having to prove their case in a federal court. And I think that turns the tables against merging parties and gives the authorities on both sides of the Atlantic the ability to stop cases without really subjecting them to the level of cross-examination which these cases would have got had they not relied on the European process to stop the merger. As it happens, exceptionally for very unique circumstances, are very unlikely to be repeated. Illumina went ahead and completed, but that's always going to be very rare. So I think that's the big takeaway, is that the level of risk now the companies are running are much higher because the protection that the US federal courts provided to parties historically has been circumvented effectively.
Fascinating. Well, Philippe, thank you for all of your insights and deep expertise on this case. Very, very interesting conversation. And now I think I will pass the baton to Matthew for a little bit more of the fun aspect of this program.
Yes, thank you, Jeny, and thank you, Philippe. It's, as Jeny says, incredibly interesting. We like to ask all of our guests, as regular listeners will know, at this point in the podcast, to please tell us something interesting or unusual about yourself, which we would not know if we only worked with you.
Well, I gave my group a presentation very recently about my pro bono activities as the chair of a youth club. And I did that really to encourage lawyers and senior lawyers, but all lawyers to engage in pro bono activities. And I found it a very interesting and complementary activity. So I'm chair of a youth club that runs 5 youth clubs in West London, dealing with the issues that face young people living at the margin of our society. So that's gang violence, young people being killed. Our youth workers have been killed on the streets. And also tackling the issue of exclusion. So exclusion from schools is a big issue in the UK, where for sometimes often relatively minor misdemeanors, young people who are facing very difficult situations at home get excluded from the main school system, state school system, and get placed in pupil referral units, from which they never go back into mainstream education. So I think the learning from all that is that with a bit of time, you can have a very substantial impact on the lives of many, many people. And as one headmaster told me, I'm saving lives, and I've worked in the city for 40 years. Nobody's told me that I'm saving lives by doing what I do in my day job.
Needless to say, incredibly valuable, and also, as you say, a bit different from worldwide merger control cases. Finally, we have our last part of the podcast, which is the Curious Hat.
And now it's time for the Curious Hat.
So here, Philippe, we ask you to choose a number, please, between 1 and 13, just at random, and each number has a question attached to it, and we will just read out the question that's attached to that number.
7.
So 7 is how would you spend your perfect weekend?
So a perfect weekend is a 20-kilometer walk along the South Downs with my dog and wife and whatever children happen to be around, followed by a swim pond, whatever the temperature, followed by a very large family meal.
So you earn your meal by doing your exercise beforehand. That sounds perfect. Thank you, Philippe. That's been extremely interesting.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.